Whether you need to verify the originality of your musical composition, identify the sources of a sample, or defend yourself against any infringement claim, today we are going to explore the fascinating world of music and sound with our very special guest who happens to be a forensic musicologist. What that means basically is he investigates cases of musical plagiarism, copying, infringement, and he's going to be sharing insights and his expertise with us. So if you know any creative or anyone who works in the music industry, or there are lawyers representing creatives such as the artists or producers, please share this episode with them and let's get creative. IP, 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 IP. Welcome to IP series, home to all things IP related, where I give you the stories, tips, and implications to business and creative decision concerning your intangible assets with real life case study. I am your host, Rita Henry Chinda. Subscribe and turn on your notification so you don't miss an episode. Cheers, guys. So, welcome to IP series. Kindly introduce yourself, tell us your name, where you live, and what you do.
Hi, Rita. First, thanks so much for having me. I've been looking forward to this, and it's going to be fun. My name is Brian McBruty, and where am I from? I'm originally from New York, but now I live in California, a little bit outside of San Francisco. I've been a musician and a composer and a sound designer, but I spend most of my time these days working as a forensic musicologist.
Wow, interesting. I think now I understand why I decided I was going to reach out to you, but you know, to my next question, what inspired you to become a forensic musicologist?
Maybe incentivized is how is how I should put it. Um, I mentioned that I was a musician and a composer and a sound designer, and uh, when I was doing a lot of that work, there was a point at which I found myself party to a lawsuit, and I needed a forensic musicologist. I wound up acting as my own kind of an expert pro se. Uh, and then shortly thereafter, I started up Musicologize, which is my music service business. And I've been doing this ever since. I don't really recommend litigation to anybody. It's stressful. It's not really fun. But I remember thinking while it was going on that the lawyers that were involved seemed to be enjoying their work. They were making arguments and building and conveying their evidence. And I enjoyed doing the musicological part. So that's really how I got started. I had to do it for myself, and I found that I enjoyed it, and I was good at it, and started up Musicologize in 2015, and I do enjoy my work.
Your transition from being a party to a lawsuit to becoming a forensic musicologist is mind blowing. But my next question to you would be, how do you now approach the task of analyzing a piece of music for similarity or originality? Are there certain tools that you use? What are your techniques? Please kindly share with us.
Yeah, the approach can go lots of ways. Uh, it depends entirely on the particulars of the music, but it starts out pretty much the same way each time. I try to arrange to go in without too many preconceived ideas. You know, the clients tend to want to spell everything out for me in the first 5 minutes of the first conversation, and I'll try to discourage that so that I can go in without any preconceived notions. I do ask my clients to write everything out for me, so that although I avoid looking at it until I'm well into my analysis, I have to make sure that I go back and investigate every one of their observations so that I can speak to their concerns thoughtfully when I'm done. But I'll avoid looking at any of that until I'm into the analysis, and I'll hope to see how struck I am by any similarities without already knowing what I'm looking for. And then the first real step is, of course, just to listen to the music over and over again. Um, I'm identifying the sections of the music that matter. Uh, I suppose I'm figuring out why I'm there, right? And and I'm listening for certain kinds of things. I'm listening for, well, let's say I'm listening to the prior work first. I'm listening to the the work that perhaps has been copied. I'll be listening for its um, signature elements. Sometimes, as I'm listening, I'll make little notes and I'll write something down like, well, if I find this in the newer work, that's the kind of thing that will probably matter. So I'll begin to try to foresee as I'm listening to the prior work, thinking, oh, yeah, if that's in the potentially copied work, yeah, that would be perhaps conspicuous. So I'm listening for those kinds of things. If I know the older work already, then I'll just go to the newer one first and see what I'm struck by. And then after these initial listenings, I'll begin a more focused analysis, and we can get into that process if it's interesting. But essentially, I write out the notes one way or another on paper or into the computer or something. I identify the similarities, and then I kind of one by one and then collectively assess the probative value of any similarities. And then with regard to, well, what kinds of things you're listening for, sometimes I'll describe it as being kind of like length and width and depth, or like an X and a Y and a Z axis. Um, you're looking for conspicuous similarity. You're looking for similarity that is probative of copying. And one of the approaches, even if it's just kind of in the back of my mind, is to think in terms of length, which is sort of like for how much musical time have these two works been similar? Is it a measure? Is it 10 seconds? However I measure it, one of the first considerations is time. How long is it similar? And then I think of width as being kind of like just how similar are they over that? Are they precisely similar over that time frame, or are they kind of similar? And then in terms of depth, or that z-axis, it's for each of those similarities, just how conspicuous are they? And that's a little bit of function of how novel is the how novel is the music? How creative was it? How unique was it? Then all of that would add up to sort of a probability calculation. What is the probability that this would have happened by coincidence, and what is the probability that it happened as a result of copying? Of course, the actual values that I, in effect, plug in for X and Y and Z in that analogy are musical ones, and music is not just is not a number. It's nuanced and detailed and subtle and complex. But I hope that's at least a little bit descriptive of the approach. And then as for tools, I have a music studio in my home, and I use the same kind of software in this work that I would use for music production. I primarily use an Apple product called Logic, but I've been using it since before Apple bought the company. That's got to be 15, 20 years ago at least. And it mostly lets me do two kinds of things. It lets me manipulate the audio. So I can get in there and I can speed it up and slow it down, and I can transpose to another key. I can filter out certain frequencies so that I can isolate other ones for various reasons, so that I can essentially concentrate on little qualities about something that I find interesting or significant. It also lets me transcribe melodies. So transcription is pretty much just writing out the music. If I'm sketching melodies and individual parts, I'll generally play the parts into the computer from a piano keyboard. When I'm asked the question, though, what kinds of tools do I use, I think the expectation is that I'm going to talk about things like a database that I can feed information into, something that will produce matches for me, and say, hey, these are the 10 songs this sounds exactly like. But I don't really rely on that kind of thing very often at all. The real tools I use, apart from the ones that I mentioned, are internal. They're my familiarity with music and with music history, and being able to connect and associate pieces of music that I know to the pieces of music that I'm looking at, And then it becomes about research because it gives me a good idea of where to go get the best relevant information that I need to tell the story.
So my next question would be: I know you had stated that sometimes clients try to interfere, but what are some of those challenges or difficulties you face as a forensic musicologist? How do you deal with ambiguity, uncertainty, or conflicting evidence while analyzing a piece of music?
Whenever I'm asked this sort of question, I always give the answer that the most challenging aspects are the human ones. Intellectual property is personal, and infringement is personal and emotional. And when I'm doing an analysis for a client who's ready to sue somebody for stealing their work, those clients are usually upset. And I should add, they're invariably very sincere. It surprises people when I say that. There's an idea that infringement cases are a money grab, that these plaintiffs are just looking to cash in, or that their real goal is to get a big settlement from a huge star defendant who they hope just doesn't want the hassle or the risk of going to trial. And that's not my experience at all. What most often is my experience is that my clients are very sincere and angry and personally insulted. And they have an understandable, but and, I'm going here with all of this, they have an understandable but usually incorrect suspicion. They've already approached a lawyer, usually, and that lawyer said, we need Brian to look at this first. And more than 90% of the time, I'm going to be having a difficult conversation with them where I need to persuade them that first, they shouldn't pursue an expensive and stressful litigation because their case looks weak. That part is obvious. But the real job becomes also trying to persuade them that they should allow themselves to let this go, to let go of this terrible feeling that they were robbed. It has never happened that I said, oh, you were definitely robbed, but it's just going to be a tough case. And, it's going to be impossible to prove. Or it's not that. It's usually that, no, what you hear, yes, I hear. I've listened to it. I heard what you heard, and I know why we're here. But they didn't steal it from you. And that's often very difficult because they're musicians and songwriters themselves. And they're quite convinced of their suspicions for all kinds of reasons. Once they hear a musical clue, something that tips them off, something that makes them begin to suspect that they've been ripped off, then they hear clue after clue after clue, and the whole story begins to take shape. Everything falls into place, and it becomes a very compelling, almost matter-of-fact situation for them. So what I hope I can do when it's appropriate is in those cases anyway, is to give them some peace. So yeah, that's that's always the answer to what's the most complicated part of the job. The most complicated part of the job is caring about your clients. And you asked about uncertainty. That's a really good question. Well, there is a certain amount of uncertainty, and that's okay. I think there's a tendency, and perhaps it's under some circumstances a tactical advantage to want to express certainty and clarity all the time, but sometimes it's just not there. It doesn't make sense for me to take a position that's not intellectually honest and sound and say things are perfectly clear when what I really see is levels of probability, and I would rather explain those. I can explain a certain amount of uncertainty if that's the most available position to take. And I suppose in some circumstances, another musicologist's unreasonable certainty is perhaps a reflection of their not having looked at things correctly. And the job is not to convince you of something. The job is to help understand the truth. And certainty is nice. And infringement is ultimately binary. You either infringe or you do not infringe. But the musicology is not always so binary. And if that means trying to explain to them that things might be, not quite perfectly clear, but here's where the probabilities lie, then that's the information that I need to try to share and convey and teach.
So, Brian, how do you now communicate your findings and opinion to the client, to the lawyers, or the court if you have to, come in as an expert witness? Are there some sort of ethical or legal issues you may have to consider while doing your job?
Most of my engagements begin with, "Hi, Brian, we need a musicologist report." Sometimes they really do, sometimes they don't. A musicologist report is a very detailed document that outlines the relevant aspects of two works, and it might prove or disprove copying, and it might prove or disprove substantial similarity. But a full musicologist report is fairly specific to litigation. So I don't recommend a full musicologist report to most clients. If I'm doing preventative work, as I usually am actually, that's what I do mostly, say for an advertising campaign where the client has a concern perhaps, and would like to avoid possibly getting sued for the music that they're going to use. The deliverable there is a document, not so involved as a musicologist report, but it expresses, hopefully, usually, my opinion that if anybody was to come along crying foul, if anybody was to say, "Hey, you stole my music," that it would be reasonably foreseeable that their accusations would be unfounded. And in addition to that document, the main communication with an advertising client might be more conversational. It'll be about general risk. Um, I often say, yeah, well, yeah, you can have the letter, you, but we should still talk about what I see as your overall risk and perhaps sit with the composer and make some changes. It happens that sometimes they just want the letter and they can move on. But when I'm doing that kind of analysis, I'm thinking about their overall risk. There's the risk of someone making a wrong-minded, completely specious accusation. But that's still real risk. It's expensive to defend against even a wrong-minded accuser. And so my goal is to leave them, probably not having to worry about getting any smoke whatsoever from anybody. Um, so yeah, so I concern myself with my client's overall risk, and that preventative or preemptive musicology is the work that I like to do best. It's more enjoyable to prevent conflict in the first place than to find yourself defending against it. And it's a reasonable step for my clients on a practical level as well. And you're in Nigeria. I don't know how, I don't actually know how it works in Nigeria, but here in the United States, we have statutory damages where if you infringe, the statutory damages potential caps out at $30,000. But if you're found to have willfully infringed, then the cap goes from $30,000 all the way up to $150,000. So I think if you go through the step of having me look at the music, then at the very least you're demonstrating that you couldn't have willfully infringed. That's my opinion. Pretty much every complaint I've ever read says, they infringed and they did it knowingly, and they should pay that $150,000. So on that basis alone, getting things looked at as a preventative seems very smart. It might take away that $150,000 possibility at least.
So, with regards to statutory um, damage in Nigeria, we do not have like a specific provision for statutory damage like in the US where there's like a stipulated sum. However, what the Copyright Act did was to give the court the discretion to award damages as it deemed fit, taking into account all of the circumstances of the case. It may also grant an injunction, an account of profits, or an order for delivery or destruction of the infringing work, as the case may be. I think, I think that basically covers it. But there is one case that happened during the pandemic where the court awarded as much as 703 million, which is about 1.8 million to the plaintiff who sued a TV, I think it was a TV station, for copying the concept of their educational television quiz program. But then, with regards to musical works, last year we had like a ring back or collar tune case where the court had issued the sum of, I think, 20 million naira against the telecom company for using the artist's musical work without his consent. So yeah, but delving right into my next question, how do you then keep up with latest developments and trends in music and musicology? Do you have sources or resources that you basically just rely on?
Latest developments and trends in music and musicology. Well, I'm a member of a few music societies, for example, like the American Musicological Society, um, and that publishes a monthly digest of musicological research papers. So once a month, I get that book full of academic papers, and that's interesting. Uh, Not as much as I used to, but I spend some time on internet-based communities that are centered around different kinds of music production, and I do that because it keeps me up to date on music technology. And music technology is forensically valuable because ultimately you're looking at the notes, but you're also trying to piece together hypotheses about why two elements sound alike. And sometimes that's informed by technology. Suppose I'm looking at a sampling case and somebody hears their recording in someone else's recording. And I listen and I recognize that the sound they're noticing is from a particular piece of technology. And I know that lots of people are using that. So it's not probatively valuable. Your record isn't at all the only way they could have gotten that sound. I'm reminded of the Katy Perry Dark Horse case, for example. Um, that case didn't make sense to me on a lot of levels, but one of them was that the timbre of a synthesizer sound that Katy Perry's Dark Horse used was the same timbre as the song that the plaintiffs had. But it wasn't unique to the plaintiff's song, and it wasn't unique to Dark Horse, and it sounded a lot like something that came off of a Fairlight synthesizer a long time ago and had been used in countless other songs. And so the idea that it would even be a component of a copying argument didn't make any sense. And if you knew the technology, then you knew to have that reasoning. So it's kind of a long story for how do I stay up to date, but um, it's also a story of how having a familiarity with music production and the way that technology influences music production. To some extent, we produce the music that the technology not dictates, but steers us somewhat toward writing, I think. And forensically, I think that's very valuable. It helps you to make more reasonable hypotheses to follow up on. As for copyright law itself, it's not like copyright law changes every day, but the winds do sort of blow in a certain direction, it seems, and pendulums swing back and forth somewhat. And while I'm not a lawyer, there is a legal side to all of this. So I read a lot of court filings so that I can see how things are tending to be adjudicated. And then with regard to how do I just stay up on music in general, I rely on my kids a lot. I don't spend that much time listening to new music myself, although I'm going to have to work on this more soon. I've been reliant on my three children and their listening habits for a long time, but my second one is off to college. And so that resource that I've depended on is going to be waning. I'm going to have to spend a lot more time listening to the pop music channels on Sirius Radio, I think.
Oh, congratulations to your second, and permits me to welcome you into the pop music culture. So, with that being said, I mean, with the new updates in your life right now, how are you going to balance work as a forensic musicologist with other musical activities or your interests? what hobbies or passion do you have outside of music?
The first answer that occurs to me is that I don't really balance my work against anything else. I like all the time that I spend um, on music. There was an article somewhere recently, or maybe it was a tweet, and it was probably in the wake of the Ed Sheeran Marvin Gaye case. And the position of the article was that it must be awful to be one of these musicologists who look at music so clinically and combatively, and um, it's not like, for me at least, it's not like that at all. Um, I I never turn off being a forensic musicologist. I just enjoy music with a certain amount of analytical processing going on in the background. And I admit it rarely shuts off, but I don't need it shut off. I'm still carried away by a beautiful piece of music, and my head still you know bobs when music is groovy and bouncing. Um, and the hairs still stand up when a fantastic moment in a fantastic piece of music happens. So if anything, I think it enhances my enjoyment of music. It's not something that I need to compensate for or find an escape from or anything like that. And I do have lots of other hobbies. If anybody ever got on my Instagram, they'd think all I do is cook food and drink wine. And I mentioned I still have 3 kids at home, so that's my foremost hobby and passion.
Since you never take off your musicologist hat, how long does it now take you to actually analyze a song?
Depending on how we define analysis, a song analysis can take only a short while, and the time involved is largely a function of the complexity of the music. Analysis, in one sense, is the transcribing and note taking and cataloging of the elements of the work, the key center, the form, harmonic function, texture, so forth. But the assessing and researching originality and substantial similarity can take a considerable amount of time. It's not linear reasoning, really. So, whatever projects I'm working on, I'm generally doing a sort of background processing on that during my waking hours. When I go to the store, my AirPods are in and I'm listening to things over and over again, gradually arriving at a better reasoned position. Or if something needs to be fixed, working on the mitigation strategy. Those things take place over longer periods of reflection, let's say.
Having transitioned from being a party to a lawsuit to becoming a forensic musicologist, what are some of the qualifications required to actually become one like you, to become an expert like you in investigating music related disputes?
Forensic musicology is very different from, say, ethnomusicology. You arrive at forensic musicology from a combination of skills and knowledge. You do need to have a strong understanding of music theory, both so that you can analyze music and so that you can communicate your findings and your observations. And you needn't have perfect pitch, although I suppose it might help sometimes. But you should have excellent, what we call relative pitch. Relative pitch enables you to identify notes and harmony by ear, and that enables you to transcribe music quickly and accurately. And it also means being able to produce from your memory what the notes and harmonies are in prior art. So you can make associations to familiar existing works, so that when you're asked, does this sound like that, rather than it being an intrinsic question, where 2 works might sound the same to any individual for any number of reasons. But extrinsically, you can answer, yeah, it does, and here's exactly why it does. Along the same lines, it helps to know a ton of music. It dovetails with relative pitch ability, that you have that sort of an internal database. It's a web from which you can make the sorts of accurate and thoughtful associations with prior art that are forensically valuable. And going back to something I said earlier, it's helpful to understand music technology and modern music production techniques because those lead you to reasonable hypotheses. And then they also enable you to prove those hypotheses out. And then you have to have a familiarity with copyright law. You don't need to be a lawyer, and you're probably not, but you need to understand copyright law and the history of copyright, bound to repeat itself, I suppose. So the more you know about that, the better prepared you are. So yeah, those are the abilities that first come to mind.
Now, let's discuss emerging technology, especially now where AI is kind of, taking over the creative industry. How do you see the future of forensic musicology, especially in light of emerging techs like AI, machine learning, and big data? How do you now intend to, deal with all of this?
Oh, AI. I have so many thoughts on how this might look in the future. I suspect I'm going to be more busy, certainly for one reason or another. AI is generative, but before it can be generative, it trains on prior art. So when I go back to something I was saying earlier about how technology influences the way we create new art, when technology makes a certain sort of thing easy, we start to get a lot of that thing, if you know what I mean. And a lot of any one thing is bound to lead to more observations of similarity. And more broadly, it just seems to me that copyright itself is not really prepared for this much technological advancement coming this quickly. The vocal sound alikes, the audio deepfakes, for example, where like I think I heard Frank Sinatra singing a Coolio song called Gangsta's Paradise. These kinds of things, as far as I can tell, are enabled by copyright law. Copyright law has always said that it's okay to make recordings that sound nearly identical to another recording. It's not an infringement of the sound recording copyright. It's a legitimate alternative to sampling. Sampling, of course, would require a license. Oh, and it's interesting. There's a case involving Rick Astley right now. Maybe you've heard of this. There's an artist named Young Gravy, and Gravy got a license to make a derivative work that interpolates Astley's most famous work, which, interestingly, Astley evidently doesn't own the copyright for. So Gravy's recording, which I happen to think is pretty awesome, actually, it sounds a lot like he sampled the Astley recording, but he didn't. He re-recorded his own instrumental, and he even got Astley's voice. I don't think he did it himself. I think he got someone to impersonate Astley's voice. So Gravy is certainly getting value from Astley's persona, his fame, and to some extent the voice itself. And Astley gets nothing. So Astley is suing, but he can't sue for copyright for all the reasons that we already mentioned. So he turns instead to ideas like right of publicity, which, again, I'm not a lawyer, but right of publicity doesn't look like a perfect fit here. The most famous case I can think of is the Bette Midler case, but she successfully sued when her voice or when an impersonator of her voice was associated with the sale of a product, not just like someone made a copy of one of her songs. So it sort of appears, from what my lawyer colleagues tell me at least, that Astley might be out of luck here. And all that's interesting, but that's not even AI. That was an impersonator. But AI means there's going to be a tidal wave of this sort of thing. So it's all very interesting, I think, and it looks like copyright is going to have to adjust and evolve to meet these sorts of new circumstances that are coming fast and furious.
So I do agree with you that the copyright law has to evolve and meet up with all of this development, fast and furious. And I think the same also applies to my jurisdiction, which is Nigeria. But what I'm going to ask you as a follow-up is, what do you foresee as the challenges and opportunities that forensic musicology may face in the future, and what would the role of creativity in forensic musicology be?
Challenges. Forensic musicology should serve copyright law. And copyright law seeks to encourage creativity. It's a balance between encouraging new work that might sometimes bear some resemblance to old work and allowing for a certain degree of that, while also promising to protect your rights to the aspects of your new work that are really the result of your own creativity. But we want music that sounds somewhat like something we've heard before. We don't want to be extremely challenged by every new song that comes on the radio or on Spotify. We want it to bear some resemblance and be somewhat relatable to something we know before, but with some new things. So copyright and forensic musicology both have to try to serve what society wants from music. I don't know exactly what the Billboard Top 10 is going to sound like in 10 years, but whatever it is, copyright and musicology both have to adapt to that somewhat. So I think that's kind of the constant challenge that forensic musicology faces. It dovetails with the challenges that copyright law faces. With regard to the role of creativity in musicology, I think it helps to remember that the point of forensic musicology is not exactly to be right. And in the case of litigation, it is not to decide what is and is not copyright infringement. It's really much more about teaching. The court or the jury is going to make the decision about copyright infringement, but the role of the musicologist is to show them, teach them the evidence that would enable them to make a well-informed decision. Since they're not music experts themselves, that can require a lot of creativity. One example that springs to mind, it can be difficult to illustrate this concept to non-experts and frankly to musicians a lot of the time. Suppose I want to demonstrate that two melodies are similar in the face of the argument that mathematically only 50% of the notes are the same. And 50% might not sound like tremendous similarity, but it depends on which notes are the same and which ones aren't. I often refer to certain notes as the blue chip notes and others as red or white, whatever less expensive chip is. For example, suppose song A were something safe like Pop Goes the Weasel, something we all know, and not a real example. I might creatively play the melody in such a way that is not precisely Pop Goes the Weasel, but you'll still recognize it as Pop Goes the Weasel, because I will make sure to include those blue chip notes, and then I'll make sure that I vary the white chip notes. So I'll not play Pop Goes the Weasel, but it still is going to have the outline. It's going to have the scaffolding of Pop Goes the Weasel, and thus argue against a claim perhaps that 50% identical notes is plenty, depending on which notes. So that's just one example of how creativity is necessary to illustrate what really is a pretty complex musical argument.
So, Brian, how can we reach you if we need to have more conversation with you? Do you have an email, a website, or a Twitter handle? How can we find you?
How can I be reached? I have two main websites. The first is just my first and last name.com. So my name is brianmcbrearty.com, and Brian is spelled Brian, and McBrearty is spelled McBrearty.com. So that's one website. And the other one is Musicologize, which is where I do most of my writing about musicology and copyright cases that are interesting and in the news. Musicologize is spelled Musicologize. I'm terrible at spelling out loud. And my email address is brianmcbrearty at gmail.com. So I can certainly be reached there. And if anybody has any thoughts or questions, I'd be delighted if you sent me a note, and I'll be happy to respond.
Fantastic. So I do hope that you had a good time with us on IP series today.
Yeah. And Rita, thank you so much for having me on this podcast. I had a good time doing it. Thanks.
Thank you so much, Brian, for sharing your knowledge and experience with us on IP series. It was a pleasure to have you on the show. And if you want to learn more about forensic musicology, don't forget you can follow Brian on Twitter. You can send him an email. You can check him out via his website. And if you enjoyed this episode, please leave us a rating and review on your favorite podcast platform. Share it with your friends and family that work in the entertainment and music industry. We appreciate your support and your feedback. Don't forget to like, share, and follow. Keep creating and see you in the next episode. Cheers, guys.